because this is publicized CPA
Oh, fantastic. Well, to everyone joining us from afar, welcome to the estate planning, tax and estate planning portion of tonight's program. We had a little bit of a delay earlier because of an unplanned fire alarm, and that kind of both, is with our theme tonight, and that things happen that are often unplanned, and proper estate plan, and the things you have in place is a. And I'm here with a new friend, Liz, who's going to ask a lot of questions, and we'll turn this into more of a question and answer kind of thing. And maybe, Liz, if you want to start with a couple of basic questions for me, or if you want me to just lay a groundwork of what I normally talk about, I'm happy to go in either direction.
Well, what's happening in the estate planning world in Florida these days?
Well, in Florida, for individuals who are moving to Florida, that's one of the more common things, is a lot of folks from places like New York or the Midwest will come to Florida and want to redo their estate plan to make sure it's compliant with Florida law. Florida is known as a great place to live for many reasons, not the least of which is no state income tax, generous homestead laws, and favorable credit protection laws. So a lot of people move to Florida and come here because of our climate and our pro-business environment that we have, and they're surprised to find out that we have for example, for a married couple, domestic laws that apply in the estate. For a married, we have something in Florida known as tenants by the entirety's ownership. And what that really is a form of joint tenants with right of survivorship. So my wife Sophia and I own property jointly. If I die, she inherits it automatically, without probate, without any court filings or any other process. But the real benefit of tenants by the entirety is that during lifetime, when Sophia and I are alive, and I go off and get into a car accident in a car that I own, that tenants by the entirety's property is protected from my creditors. It's a really nice creditor protection tool that a lot of people moving to Florida are not aware of. Conversely, if we have a bank debt that we're both responsible for, tenants by the entireties isn't going to save us from a creditor protection standpoint. But for a lot of people in Florida, it's a very important estate planning technique. And I say a technique, but really it's just titling. So a lot of married couples in Florida want to make sure that their bank accounts, their joint bank accounts, are titled as tenants by the entirety. It's very important. Homestead laws, which I know a lot of us are familiar with. And homestead is kind of seen as this like enigma. It's very beneficial to the resident, but it's really difficult to understand. And it's kind of multifaceted. The most common thing that people think of when you hear homestead are, oh, my taxes are lower. Well, that's one element of homestead. That's the property tax homestead exemption. And the way you get that is if you own property or if you have an interest in property in Florida, you make a filing with the local property appraiser's office and you get $50,000 off of your homestead assessed value. You also get the ability to have your home not increase by more than 3% per year. It's called the Save Our Homes Amendment each year for property tax purposes. So my grandparents who bought their home in 1987 for $50,000, well, come to think of it, now it's worth $400,000. They're still paying taxes on the level of the $30,000, $50,000 maximum growth, and that's a very important homestead technique that's very favorable. But the more important homestead protection for a lot of people is the creditor protection, and really what that is an absolute protection against just about every creditor, regardless of value, with really two kind of qualifications. First, do you live in the city or do you live in an unincorporated part of the county? Living in Collier County, most of Collier County is unincorporated, right? Except for Marco Island, Naples, maybe Everglades City, and a few places. If you're in the city, your homestead restriction is down to ½ an acre. You can have a penthouse, the most expensive penthouse in Naples or Marco Island, and it can be worth $15 million, and that's protected. It's under ½ an acre. But if you have a house in Naples that's maybe worth $8 million and it's on an acre, only half of that is protected. But if you live in Golden Gate Estates and you have 100 acres of property, you're protected regardless of value, because outside of city limit, it's 160 acres of property that's protected for homestead. So that's another really interesting part of Florida law that a lot of people don't necessarily know offhand. They think, oh, property taxes. But no, the creditor protection is an important part of it. There's the third part of homestead that needs to be considered in some instances, and that is the restrictions on divides. I'm married, I have 2 minor children. If I put in my will that I'm gonna leave my homestead to my new friend Liz, that's not gonna work. Because under the Constitution, I'm married, I can only leave it to my spouse. That's just the way the Constitution is built in. So that's the third aspect of homestead. That's not really something that is as a planning technique as much as it's a guardrail. You have to be aware of it if you're doing estate planning.
What would you say to a single person who comes to you for estate planning?
Yes.
And this single person could be never married, divorced, widowed, or widower, and that person never had any children. They own a home, they have no mortgage, they have named beneficiaries for all of their retirement accounts, they have set up all of their checking accounts and savings accounts so that they transfer on death to their siblings.
Sure.
Okay. But they own a home to leave the home to their nieces, nephews, to their nieces. What would you say to that person, or what would be the best way to structure that?
Okay. Well, as Weston will probably know, we almost never suggest leaving assets outright to beneficiaries. There's a variety of reasons for that. I mean, you can have your niece or nephew be the most prudent and responsible and able to handle. But if you leave them assets outright, if you leave those assets are ripe for creditor claims, potential divorce, and if your estate is large enough, potential estate taxes. So what we typically recommend is that assets can be left in trust for the benefit of that beneficiary. And that beneficiary can have a trust that they can be the trustee of, and they can control, and they can take distributions as they need for something called health, education, maintenance, and support, which is a broad standard for living expenses. What's more is that the beneficiary can control what happens on their death. And that can be held in a creditor protected manner outside of the estate tax system. That's generally what I tell most clients, married, single, whatever. If you leave assets to somebody on death, you probably want to put them in trust.
But let me explain this situation. This is a retired Collier County firefighter who owns a home that's worth about $700,000 and has 4 nieces and nephews and wants the home to go to those 4 nieces and nephews. And only wants to plan for that because this retired firefighter only has already planned for everything else.
Okay.
The checking accounts are already going to transfer on death to his siblings. And the retirement benefits also have named beneficiaries. There's no life insurance. The only thing he wants to plan for is the house. That's it.
Well, my response to that would be, even if you have beneficiary designations, maybe make them payable to trust, so you can avoid the potential pitfalls that you have if assets go outright. Regarding passing the house itself, there's something called a ladybird deed or a contingent remainder deed. That is a very popular mechanism we use here in Florida. And what that is a deed that I say, for example, I'm going to leave my house on death to Liz, but during my lifetime, I'm going to retain the right to live in the house and to divest the house passing to you on your death, meaning I can change my mind at any point. But if I don't change my mind, the house then would pass outright to you on my death. Outside of probate, right, without any court filing, the only thing that would have to occur is my death certificate would have to be recorded in the county. That is a very easy way to effectuate what, in your example, the firefighter would like to accomplish without doing probate and all of that process.
Well, let's say the firefighter does not want to change the current deed.
Okay.
Does not want a ladybird deed.
Okay.
Just wants a simple will.
Yes.
Giving the house to the 4 nieces and nephews.
And this is a homestead property.
And it is a homestead property.
Okay, well, the thing with homestead is that to get you have to do a filing on death to get an order determining homestead. And most counties, in fact, I think all counties now, require that you open a probate proceeding to get that order. It's this really weird roundabout way of doing it. So what I would do in that situation, and I've done this for many single clients, is I come up with a 4 or 5 page revocable trust that says this is my trust, and it's basically mimics what the will would be, but it's a private document. And what I would do is, I know that the firefighter doesn't want to change the title, but deed the property to the trust, or do a ladybird deed.
Doesn't want to deed the title
Well,
over to
if
the rest of the trust.
he doesn't want to change the title at all, then his heirs are going to have to deal with probate, which is not the worst thing in the world.
But the only thing going into this probate is the house, because all the money.
So I would say, okay, well, look, your heirs are going to spend $3,000 to $4,000 dealing with this on debt, or for a fraction of the cost now, you can deed it in a manner where you can control it and nothing. File a homestead application, because if it's for your local trust, you don't need a revocable. And if you put certain language on the deed, the county recognizes that and maintains your homestead exemption. So that I would be somewhat firm in that. And if the client wants to, if the firefighter wants to make that decision, just have them acknowledge it. It's their call at the end of the day.
What do you ever, in your wills, do you ever put a direction to sell property?
Not necessarily homestead, because homestead property, when there's a direction to sell, loses its creditor protection exemption on death. So if I say on my death, sell my homestead property and split the proceeds between my friends Liz and Wesley, and if Wesley has creditor problems, well then Wesley's share of the inheritance could be subject to creditor. And if I have creditor problems, that direction to sell doesn't make the homestead protected for my creditors. Because the beauty of the homestead in Florida is that protection survives death. Okay. Let's just say that there's a gentleman who was maybe suspected of murdering his wife and somebody else in the state of California. And let's just say that he had a judgment against him for that. And he moved to Florida and he bought a house. That gentleman's house on death is still protected from the civil judgment in the state of California. Right? That's why people like that move to Florida for some reasons, in addition to the climate. That protection survives death and can save those assets for heirs. It's an extreme example. I only make it extreme to illustrate the concept and how strong homestead protection is.
What are you telling estate planning? Question.
So that's a good question. The federal estate tax is a really hot button item for a lot of people. Just to give kind of a summary of where it's at right now. Each person has an exemption level of $12,060,000 minus what they gave during lifetime. On death, you can pass that much to non-charities and non-spouses without having an estate tax. That's an extremely high level. In fact, it removes about 99.9% of the families from the estate tax. However, in 2026, that amount is supposed to come down to about 7 million. And who knows where political climate's headed? I mean, in just as recent as 2016, that ball was 5,450,000. And just as recent as we talked about 17 years ago. I mean, 17 years ago it was about $1 million, and now we're in the realm of 12 million plus. What I tell clients who have estates that might be subject to the estate tax is starting early is a great way to plan. Because if you start, creating trusts for spouses and for other descendants early, and you allow the phenomenon of time value of money to take hold, then what you can do is push assets outside of an estate. And a very common thing that we do these days is we form something called a SLAT, or a spousal lifetime access trust, spousal limited access trust, whatever you want to call it. It's simply a trust that one spouse creates for the other spouse and children and descendants, whoever else. And the reason why that's so beneficial is back to my example. If I fund a trust for my wife, Sophia, she can live off of that trust, right? If I fund trust for her and I use my 12 million exemption and put assets into this trust, she can benefit from that even though I used some of my exemption that might not be here in 2026. I can engage in estate planning transactions with that trust. where I transfer assets to that trust and freeze the value at maybe a depressed value now, but later on any appreciation can pass outside of the estate taxes. That's a very common estate planning tool that we use. It's so but it is, we've given hours to talk on that topic alone. It's a very common tool for varied individuals who want to do estate tax planning. There are also techniques that involve charities, charitable remainder trusts, charitable lead annuity trusts, or the charitably inclined individual, or even those individuals who just hate giving money to the government and want to substitute that for a charity. You can design a structure that someone can put assets into a trust and either have the charity receive payments for years, with non-charities receiving the interest, or flip that around, remainder, and have the charity receive what's left after certain years after beneficiaries get payments. And these structures can be used not only to accomplish estate tax objectives, but also income tax planning, because those structures can be used to defer taxable income if you have a sale of appreciated assets, or if you know someone who's going to sell their company or recognize a big liquidity event. They're very useful tools. So those are some of the things that we do for individuals who want to escape the estate tax or minimize the risk of these.
What do you say to adult beneficiaries of their parents' estates? Both parents have passed, and both parents have left monies to their multiple children,
Sure.
all of them equally as beneficiaries of what was the revocable trust, now it's irrevocable. And these beneficiaries have all agreed amongst themselves that they would rather have the money now.
As opposed to in trust?
Yes.
Well, what I would try to convince the beneficiaries that it is not a good idea, for the reasons I mentioned earlier. Lack of creditor protection, lack of divorce protection. Unfortunately, here in Florida, we have settled law. The Peck case is one of them, where the trustee and the beneficiaries can get together and say, "Hey guys, we're going to just break up this trust and split everything up." We have put clauses in our trusts that say, under no circumstances can a trust be amended after it's irrevocable. In fact, what I'm doing is I'm naming a Bahamian foundation as a beneficiary of this trust, and I'm appointing a lawyer who knows my intentions to be the manager of that foundation, so that's one beneficiary who can dissent against breaking up that type of trust. Some clients will take it a step further and just say, well, children, you're going to have a trust for your benefit. We're going to name a trust company to be trustee. Or we're going to name one of the hardest, most stubborn lawyers I've ever met, Wesley Dixon, be trustee of that trust. And he's going to say, no, you're not going to be able to break up this trust. When I talk to clients, I explain to them there's a continuum of control and access. There's the outright, here's everything, I don't care. And I've had clients with estates in the millions say, I don't care. When I'm in the ground, I don't care anymore. I want everything to go to my kids, and they can do whatever they want. And I pled with these clients and said, don't do that. Don't make it hard on your clients. Shifting down to the other end where you have a co-trusteeship that is required. I leave a trust for Wesley, but I say Wesley has to have Michelle as co-trustee with a South Dakota trust company or with certain times. And Wesley is limited to receiving distributions only under a trust company. Is limited to certain circumstances. That's one side of the continuum. A lot of clients kind of find somewhere in the middle, where maybe they have beneficiaries who, in a perfect world, they can leave their inheritance to outright, but for those creditor protection and estate tax planning techniques or considerations we mentioned. So instead we say, we leave a trust for Wesley, and Wesley can be the sole trustee, and he can manage it, and it's protected from his creditors and his potential future divorcing spouse.
So in the situation that I just described, there's two trusts,
Sure.
One that was set up by the mother, one that was set up by the father. Both parents have passed. They had 4 children together, all of them living. The children have children of their own. There may even be a great-grandchild at this point. One of the 4 children is the trustee of both of these trusts. It's this person who's the trust who is in communication with the attorney and trying to convince the attorney that not only the children, the 4 children, but all of the other offspring agreed to this. And is pressing the attorney to terminate both trusts and just have it distributed, not to the grandchildren or the great-grandchildren, but to the 4
And
children,
the trust says children for lifetime, and then it goes down to
to the descendants, yes.
well, as a fiduciary, I would not agree to that. As a trustee, I would not agree to that because of
Well, he
liability.
is agreeing to it.
Because of, let's just say that, it's not necessarily likely, but it's theoretically possible that one of the children would die and that their children would subsume to the deceased child's interest. And in that case, what you've done is kind of breached your duty to those remainder beneficiaries. And as a fiduciary, I would be very reluctant to do, or to eliminate that type of trust because of those concerns. One way to do it would be to go to court and get a court order, having it blessed. And if that's what everybody agrees to, that's fine, but the trustee might have liability in 15 years if, Junior grows up to be an adult and finds out what happened, and, and he says, why did this go this way? Why was my inheritance taken from me in this manner? So those are my words of caution to a trustee serving in that role. It's obvious that the settlor, the grantor, wanted a structure in place. The intent was to have a protected trust structure in place. And by, I guess, going against that intent, you have these fiduciary concerns and you really just not effectuated the settlor's intent, which is paramount. Yeah, so it's an interesting situation.
Here's another situation. Janet. Both parents set up trusts. The trusts, all of the trusts for 4 hold, both trusts hold partial interests in the father's construction companies and real estate companies in Miami-Dade County. And one of the 4 children was named as the trustee of both parents' trusts that hold all these partial interests. The trust documents themselves say that the beneficiaries, the other 3 children, who all happen to be female, they are entitled to income from these trusts. The only son who's managing these businesses and is also the trustee of all 4 trusts is for years not making any distributions to his sisters, claiming that there is no income. Not enough income to distribute.
Is income determined under the trust, or is it determined under the principal and income act statute?
Well, this is just in the beginning stage.
Okay. The trust doesn't mention a certain threshold for income. It just says
I haven't got.
Yeah, so it sounds like it's a potential fiduciary litigation matter.
It is.
Yeah.
Yeah.
I mean, there are mechanisms to remove a trustee who is not carrying out their duties. Generally, the conduct has to be extreme.
Well, in this particular case, that trustee has been removed.
Okay, interesting.
And a judge has appointed another successor trustee who is now trying to figure out what's going on.
Yeah, that's unraveling the ball of yarn. It's always entertaining and cumbersome. Wesley, did anyone have any questions?
No questions so far.
This is great, though. You keep firing away. I can go on to the topic.
How would you approach this situation? A 64-year-old man who is retired from running a chain of auto body shops in Pennsylvania and has retired to falls down the stairs of his 2nd-story home and dies 5 days later in the hospital. His wife of 18 months was in the home. he had he was married to her for 18 months, but never wrote another will, recognizing her as his wife, but she was obviously his wife.
I'm laughing because this is the makings of a law school exam.
There has been a significant amount of litigation, including the unraveling of business deals gone wrong in Pennsylvania, a wrongful death lawsuit against the wife, and over $2 million in legal expenses have been paid out of the estate. The legal counsel for the wife, who has gone through a wrongful death lawsuit, who settled with the estate, is now disputing all of the legal expenses that have come out of the estate money.
Wow.
All kinds of lawsuits, many of which had nothing to do with her. Law firms having to be hired in other states where all of these disputes took place, where the Florida attorney was not admitted to practice. How do you approach those types of issues with what appear to be excessive attorney's fees?
Yeah, that's a good question. Obviously, I think you have to look at them one by one, right? You can't just lump them all together. You have to look at each firm separately or each case separately. Who would hire these lawyers? Was it the Florida appointed fiduciary?
Well, it was the personal representative,
Yeah.
who was the 64-year-old decedent's daughter from his first marriage.
She was probably unsophisticated and just went with.
She was 25 years old when her father died.
Yeah, with that, I mean, you always want to make sure you hire reputable lawyers. You know, it's even in that case, the fees can get excessive if there's not a handle on what's being accomplished. Particularly with out of state, it's very difficult to do so. I mean, it's easy to say, it's just hard to do, right? If you have litigation in Washington State, you know, you may not know anybody in Seattle that can handle something like that. But what I would suggest is making sure at the outset of that engagement, getting an idea as to what the fees might be. And the problem with litigation, and I'm not a litigation lawyer, but the problem with litigation is that fees can get really high really quick, right? I mean, there's an old painting we used to have in our office, and it was a skinny plaintiff and a skinny defendant pulling this cow, and there was this judge just sitting there, and there was a lawyer just sitting under the cow. And it just describes a lot of litigation matters in that the lawyers are sometimes the ones who win the most, right? Both the plaintiff and the defendant can be, and it sounds like that's what's happened in a lot of these cases. But you know, as a lawyer, I think when I talk to clients, I try to be very clear about how much things might cost and outline that and explain to a client, look, this is an option. You can go through that door, but if you go through that door, it might cost you this or potentially more than that if things go a certain way. And that's with litigation, it's difficult to tell. But planning, you can kind of get a better idea as to how much something might cost, or at least give a better, more accurate range. But litigation matter, you know, it's very difficult, especially if you're fighting on multiple fronts. That seems to be the case here.
What do you tell your clients, let's say a personal representative, somebody who's not familiar with being a personal representative and not familiar with the obligations of the PR, board, handle the going forward? What needs to be done in, let's say, the first year after the decedent's death in terms of taxes?
Yeah, we have a great letter that covers the obligations, particularly the tax filing obligations. You know, but I like to say to the client, make sure you have a good CPA involved. Because if you have a good CPA, that CPA is going to know some of the deadlines and some of the tools available for post-mortem planning. A 645 election, you're late, trust made that 645 election. And for those folks who don't know what that is, that's an election to treat a revocable trust as part of the estate for income tax purposes for a limited period. And by doing so, you can kind of defer income by electing a fiscal year end, which is a fancy way of saying a non-calendar year end. That's one of the threshold things that I like to do. You know, obviously explain the need to file a final income tax return for the decedent, and also a 1041 for the estate and any trusts that the decedent may have established or may have become into existence as a result of the decedent's death. If we get into the estate tax threshold, there's the potential for filing a return. We talked earlier about the $12 million exemption. If I die with assets in excess of that amount, then I have to file an estate tax return. Even if I leave my entire estate to my wife and qualifies for something known as the marital deduction, where I don't pay an estate tax, I still have to file a federal estate tax return. If I die with assets less than that amount, what I would typically tell someone, I would tell the surviving spouse, consider filing a 706 or a estate tax return for portability reasons. And what that is if I die, for example, with a $6 million estate and I have a $12 million exemption, my wife can file an estate tax return for me, and she can use my $6 million of unused exemption and apply it towards her exemption. So that's also a decision that comes up and something that should be communicated to personal representatives. These are filings that sometimes are not necessary, but there are tax benefits to doing so. And that's, I think, very important part of an administration, you know, as well as getting the assets to the beneficiaries and paying creditor claims. It's very important to make sure that's handled.
What would you say to somebody who comes to you for estate planning and either intentionally or accidentally reveals that he or she has not paid all back taxes?
Well, I personally would pick up the phone and call someone. We don't do tax controversy work at our law firm, but I would try to connect them with a lawyer who does specialize in that area, and I would suggest that they follow that lawyer's advice, which typically involves, you know, trying to remedy the unpaid taxes. Different can of worms if we're talking about offshore, like non-compliance for filing FBARs or 3520 tax returns that are required if there are accounts overseas or trusts. But my first recommendation would be talk to an expert in that area. Just like if you had someone who came to me and said, "Hey, I'm having a hard time with my insurance company," I would say call James Constable or someone like that, you know, and not necessarily someone who isn't qualified. And that's what I would do in that regard. But it's certainly important to handle.
So suppose I'm an estate planning client and I come to you and I say, New York State claims that I owe $20,000. I'm just not going to pay it. I don't have a spouse. I'm naming my brother as my personal representative in Florida. Will my New York taxes just go away because I don't die in Florida?
The first thing I would say is, I don't know because I'm not a New York lawyer. But I can get you in contact with someone who is familiar with that area of law. I certainly would encourage, you know, before encouraging payment on taxes that I wouldn't even know to understand, I would refer that to someone who does know New York tax law. That said, the most likely advice is going to be something to the effective, pay the taxes back, because I'm not sure how serious that claim is. Earlier, I talked about homestead, and I mentioned the exceptions, and I didn't really get into them. Well, from a IRS standpoint, all the IRS money is a big exception to it. If I owe the IRS money on income taxes, they can put it on my house, even though it's, you know, 10 and 5, my wife and I own his homestead. It doesn't matter, because it's an exception due to the supremacy of the Constitution. Another example for homestead is mechanics liens. I hire a contractor to repair my roof, and I don't want to pay him. Well, he did work on the house, he put a lien on the house. And then the two other examples, one of them is baked into the Constitution. That is the knowingly and voluntarily exception. I gave a mortgage on my house. The bank can foreclose on my house. I gave the mortgage. The fourth one is called the equitable lien, and that's a little bit more of a creature of case law. I steal money from Wesley in a business deal that I swindle them out of in complete fraud, and I take those funds and put it into my new homestead. Those a lien on the house, or I rob a bank and use the proceeds to buy a house. I mean, you can't do that anymore. But back to the old days when you could use cash for those things, something like that. That's where the equitable lien is. I don't know. New York lien may not equate to that in Florida, but it can cause a heck of a lot of problems. And I'm pretty sure that it would prohibit on death how you leave assets, and at least open up a mechanism for a New York creditor, particularly the state of New York, to file a claim against the estate. In Florida, we have a kind of a really big loophole that doesn't get a lot of publicity because I don't think the estate planning lawyers want to call attention to it. And that's the non-probate loophole, right? Think about this. In your example earlier, your client who has everything titled in a manner that's going outside of probate.
Right.
But let's say that client has $200,000 of credit card debt, right? The credit card company, their sole remedy against the decedent is to file a claim in the probate estate within 2 years after the death of the decedent. There's no mechanism that I'm aware of in Florida law that permits that creditor to go after pay on death accounts and survivorship mechanisms. In fact, there's a whole practice of law in Florida under elder law for Medicaid planning that uses that loophole as a basis for avoiding repayment of Medicaid advancements. So it's an interesting question that you bring up regarding New York taxes. I just don't know if there are constitutional implications under the full faith and credit clause or how that would be handled. Anytime the taxing authority gets involved, I get a little weary of getting too cute with the planning, right? So that's.
Well, let me change the facts a little bit.
Sure.
Suppose that the state planning owes 50,000 to the feds and 20,000 to New York State, based on the same tax years.
Okay.
How would you advise that estate planning client how it should be considered in the estate plan, and what is left when the brother is on?
Yeah, I would suggest trying to work out a repayment. And first step, finding a lawyer who can help with that, and making sure that it's addressed. As a tax advisor, I have a duty to recommend that clients fulfill their tax obligations. You come to me and say, hey, Chris, I made a $3 million gift 2 years ago and I didn't report it to the gift tax return. Well, I have to give you the list of file a gift tax return. And it's your decision to whether to file that. But I can't tell you not to file it. Similar concept here. So, I would obviously reach out to someone who does handle tax compliance work, tax controversy work, and try to get that negotiated to a point where it's palatable. That makes sense. Any other questions or?
A number of rental and commercial properties in Minnesota and home and commercial properties in Florida.
Where's your dominant?
Legally Minnesota.
Okay. Well, you're
But-
technically a Minnesota resident, but what's the tax rate in Minnesota? Tax. Spend a little more time.
Do you, I mean, is it as far as planning to your state, just could be considered adventure here? I mean, they plan that down here.
I think so. At the beginning of this talk, I gave another great reasons why Florida is a great place to live.
Didn't mention other ones.
So there's that too.
That's just a given, everybody. knows
Right.
that.
So I mean, we have it still. You know, I mean, winters are every year. So yeah, I would suggest doing a plan here. Now, plan on being a Minnesota resident. I would suggest a Minnesota council because I think Minnesota has a state tax, if I'm mistaken.
Yeah, they do.
Yeah.
Married couple, what if I have like a Florida driver's license, all of that years ago, so it would show that you see you as a Florida resident, and I get a discount. So I've been down here, and there have been a number of years I've spent more than 6 months down here than I do in Minnesota. So my husband still works and this license still in Minnesota.
Well, there's no rule that spouses can't have separate sides. No rule that spouses can't have domiciles. It has to be bona fide. Right. Moving there, you know, my plan is you actually have to live here. You have to go through the you've done. Well, your tax returns, you can put a statement saying that I was in South one is in Minnesota, things like that prove your domicile.
Okay.
Because the thing here in Florida, we don't really care if you're a Florida resident. We have no reason for you to be a Florida resident or not, right? It's Minnesota that's going to care because they're going to look for their income taxes from you.
Okay. So I could establish domicile here and homestead our house here.
Yes.
If I ever get it rebuilt after the end. Okay.
Guys, well, this was fun. This was unorthodox and very nice and loose after we talked about insurance claims. But thank you for this idea, Liz.
Oh, your idea.
This impromptu discussion. This was nice. And thank you all for joining us. If you want more, you know where to find us Saturdays at 11 on our normal webinar schedule. Everyone have a good evening, and we'll see you soon.